Hello from New York City. I hope everyone is doing okay in these continuing difficult times. I'm Joanne Abbott-Green, the executive producer of Mondo.nyc, here with my Mondo partner, Bobby Haber, who's off camera, to welcome and thank you for sharing part of your Saturday with us. Mondo has had the privilege of partnering with the Harvard Law School Recording Arts Project for these past couple of years, with our continuing legal education program, Pro Bono series, and now our second virtual conversation. The Recording Artists Project is a student practice organization serving the music community by offering pro bono legal services to local and national musicians. RAP enables Harvard Law students to perform hands-on legal work for clients under the supervision of a licensed attorney. Since its founding in 1998, RAP alumni have gone on to work for and represent artists, indie and major record labels, the Copyright Office, and media companies, and taken their passion for music and entertainment law far and wide across the legal profession. Our moderator today, Anil Partridge, is a second-year student at Harvard, events director and former team leader with the Recording Artists Project. Anil earned a BA in philosophy and English literature with high distinction from the University of Toronto, where he worked as a teaching assistant in the Department of Philosophy and a research fellow in the Faculty of Law and the Department of English. A lifelong classical violinist and avid jazz guitarist with a deep passion for music, Anil has worked as a session musician in hip hop, folk, and indie rock genres, and plans to practice law in the music industry, directly representing artists. It's my pleasure today to welcome Anil Partridge.
Thank you so much, Joanne. Just to offer some introductory remarks and introduce the panel today. We're the Recording Artists Project. As has been mentioned, we're a student practice organization at Harvard Law School, devoted to pro bono legal services offered to musicians and promoting student engagement with copyright and the music industry. Work for hire agreements, copyright split sheets, band agreements, licensing questions. We help clients with all of these, partnering with Berklee College of Music and wonderful institutions like Mondo to inform the general public, to serve clients, and to help students in these areas. If you're in need of legal advice or have questions about law and the music industry, feel free to reach out to Will, our intake director, via his email, which is walker.jd22@hlsclinics.org, or email rap at hlsrap@gmail.com. So without further ado, I would love to introduce the panel. Today, we are being assisted and overseen by Brian Price, who is a practicing lawyer with a vast experience in an array of transactional law areas. Brian founded and continues to direct the transactional law clinics at Harvard, consisting of the business and nonprofit clinic, the real estate clinic, entertainment law clinic, and community enterprise project. Brian is also the founder of RAP and the founder and faculty advisor for the Harvard Law and Entrepreneurship Project. We are very lucky to have him here with us today. Speaking to you today also will be Will Walker, brilliant and passionate student, our intake coordinator. He is a 2L with a passion for entertainment and intellectual property. And also speaking to you today is Chris Zheng, our brilliant and talented oversight director. Chris is also a 2L with a deep passion for copyright, the arts, and artists' rights. We would also love to just give a shout out to Olivia, another member of our board who contributed a great deal to this presentation, and we're very grateful for the work that she did. So I believe we have an image of the board for the coming year. So this is the board for the coming year. Lowry, the president. I just wanted to show you all who we are. Lovely and talented incoming board for the year. And so, yeah, without further ado, I think we will jump into to these questions on fair use. So can you copyright a feeling? This is a question that has been raised recently, and there's some doubt about it after the blurred lines decision that is notorious and that I'm sure many of our audience members are aware of. But I think answering these questions about copyright and about fair use, which is the subject of today's conversation, really begins with an understanding of what is copyrightable. Can you copyright an idea? Can you copyright a feeling? Are there particular elements of songs, lyrical works, written products that are copyrightable? So individual elements can receive copyright protection. Expressions typically are protectable, not musical or literary ideas. But there are interesting questions raised about whether or not individual component elements of a song, of a literary document, are protectable versus the collective expression of those elements. So the copyright clause of the Constitution itself kind of lays out this tension between a firm protection for certain expressions and this idea that the ultimate purpose of that is to promote the progress of the useful arts and sciences, which is really where fair use comes in. So in today's talk, you'll be hearing about fair use. You'll be hearing about the factors of fair use, how they come up in musical practice, how they affect sampling practices, what infringement amounts to, just when you can appeal to fair use, and when you can appeal to other related defenses. And we're going to clear up some common myths and misconceptions about fair use. It will begin with infringement, and we'll proceed into a discussion of fair use. And so on to the next slide. So a recent legal decision, blurred lines, raises this question: can you copyright a feeling? So copyright infringement typically is analyzed by considering whether a potential infringer had access to a work that they allegedly infringed, as well as if their work was substantially similar to the work that was copied, or in the alternative, proof of actual copying. But it raises an interesting question. If you have actual copying of a musical work, but no individual element in that work was copied, is that infringement? Marvin Gaye's estate in the Blurred Lines case accused Pharrell of essentially having perjured himself in an interview with GQ by admitting that his goal in producing the song Blurred Lines with Robin Thicke was to reverse engineer a song written by Marvin Gaye. In his words, to build a building that doesn't look the same but makes you feel the same way. And he did that in Blurred Lines and admitted that that led to legal liability. So this raises questions. Is that kind of an approach substantially different from an artist using a creative tool to emulate the sound of another artist, using autotune, for example, to sound like Kanye West's 808s and Heartbreak? Is it different from a rapper emulating a particular flow in a very conspicuous way, and using individual elements that are distinctive to that artist's flow? Is it substantially different from, dub musicians or reggae musicians, artists within genres emulating conventions characteristic to a particular genre, for instance, those pioneered by a particular individual in one track? Just where are the lines with respect to infringement? So these are all questions that have been raised recently by this decision, and motivate a discussion of fair use in our mind, which is at the next slide. So fair use itself is motivated in this way. If there is a secondary use, so if you take a sample, you take some constitutive element, a technical term, meaning just some individual part of a copyrighted work, a drum line, a bass line, a portion of the lyrics. If a secondary use, such as sampling, adds value to the original work, if the quoted matter is used as a raw material and transformed in a way that creates something new, that type of activity is meant to be protected by the fair use doctrine. for the broader enrichment of society. So there are 4 fair use factors that courts have to consider when a defendant raises a fair use defense to copyright infringement. The first is the purpose and character of your use. So, for example, if you sampled a piece, a song, or you appropriated lyrics from a particular song, was this with a view to make an artistic claim, to parody the original song, or was it simply a taking of something that seemed culturally interesting, rich, or sonically interesting? What was the nature of the underlying copyrighted work? Courts will often consider if the work had an entertaining or artistic function, or if it's primarily informational in character. Another important factor, the amount and substantiality of the portion taken. Are you taking just a tiny chunk, a 2-second horn hit, or are you taking a few lines of lyrics, or a much longer segment, as in the Pound Cake case, in which Drake took a large chunk of Jimmy Smith monologue on a rap album, which, on a jazz album, which will be discussing later. And finally, because ultimately the purpose of copyright protection is to create, to incentivize creative work and to protect an artist's economic interest in exploiting that work, courts look to the effect of the use upon the potential market for the original work. So, for example, in a clip that we will be hearing very shortly, Puff Daddy, in the well-known song "I'll Be Missing You," took a large sample from a Police song, "Every Step You Take," "Every Breath You Take," I'm sorry, which is at the core of the song, is unmistakable, and did so really without kind of altering the way that it sounds very much, without commenting on the original work in a meaningful way. And I mean, the fact that it fails all 4 fair use factors is illustrated in the fact that Puff Daddy ultimately settled with Sting, who now receives 100% royalties on the song, which provides a steady cash flow of $2,000 a day to Sting. But it's kind of an object lesson in where you can go wrong with some of the fair use determinations you might make. So I think we have a clip teed up here for you.
Living your life after death. Every move I make, every single day, every time I pray, I'll be missing you.
So Faith Evans sings the hook, which is the exact melody and many of the lyrics of the original Police song. The purpose and character of the use was simply to take the song for its melodic interest and its kind of generally romantic theme. The nature of the original work was entertaining. It was a musical product and a copyrighted work. The portion taken was a substantially large portion and the most recognizable portion of the song, although there's an interesting conflict there in the way that parody is treated as a paradigm case of fair use, because parody works require quoting the most recognizable portion of the work. But in this case, that actually is problematic. And then finally, of course, using without permission that hook directly affects the potential market for samples of the original work. So I think we'll be moving on to a discussion of copyright infringement, because fair use is a defense to copyright infringement. And I think it's a useful place to begin, just figuring out what copyright infringement is itself. So we'll be turning to Chris for that. Chris, what is infringement itself? And how do you actually know if you're infringing a valid copyright?
Great question. Thanks, Anil. It's such a pleasure to be here today to speak with all of you. I hope that we can be helpful. And also feel free to drop any questions that you have in the chat. We'll be trying to answer certain ones individually or save some of the questions for the end. So keep those questions flowing and we'll do our best to answer them. So on the question of copyright, I think it's important to first start with a quick review of what is copyright. So copyright is the system of protection for your work as an artist. and it's protected by the Copyright Act, which grants certain rights to you. Specifically in music, there are two different forms of copyright. The first being a composition copyright, which is the music and the lyrics of a song. And the second is a sound recording, which is the actual fixed recording of a song, the actual track. So usually a writer is going to own the composition rights, and then a record label is going to own the sound recording copyrights. Of course, this is subject to a lot of caveats if it's self-released, in which case the artist is going to own the master. And it always depends on what deals are specifically reached between the artists and other groups like record labels. But that's the general rule, is those are the two different types of copyrights that exist inside of a piece of music. So now we can look at Section 106 of the Copyright Act, which gets into the exclusive rights. They're listed here on the slide. We have reproduction, which means that nobody can make copies of your work without your permission. The right to create derivative works. So only you can sample, remix, parody, or option movie rights for from a book, for instance, with a copyright protection on your work. Distribution, only you are allowed to sell, lease, lend, make work available publicly. Public performance, controlling when and how a work is performed publicly. Think concerts or when you're sitting inside of a restaurant and music is playing. Public display, which is controlling how your work is displayed. In this case, you can think of things like lyric websites, guitar tabs, sheet music. And then finally, digital transmission. This only applies to sound recordings where you can control interactive play, such as Spotify, streaming, and digital downloads. So what is copyright infringement? Infringement is basically what happens when you do any of these things without authorization from the artist or the rights holder. So that's whenever you hear about court cases where somebody has made an unauthorized version of a song or has used part of a song without permission, which is what we're going to get more into today. That's an example of copyright infringement. So when courts look at copyright infringement, they're primarily examining three different things. The first is that the plaintiff in the case, which is the person that is bringing the suit, needs to have a valid copyright to a work. In order to have a valid copyright, you need to register with the United States Copyright Office. And it's important that registration is a precursor to being able to file claims in federal court to protect your work. The second thing is that the defendant or the person that is being sued copied the work. This is what the court looks at as, quote, copying in fact. And then there's copying that was improper. So making sure that the copying did happen and that that copying was unauthorized and unlicensed. That is the term copying at law. When the actual cases go before a court, there are two factors that they primarily look at. The first one being access. They look at the particular chain of events that is going to link a defendant's work to a plaintiff's copyrighted work. And this has been proven in past cases by things like somebody literally owns the record of the artist that they are accused of copying, or in many cases nowadays where the plaintiff's copyrighted work has been widely disseminated. So if you are being accused of copying a song that is currently #1 on the Billboard Top 100 chart, you're probably going to not have a good claim to argue no access. The second thing is substantial similarities. The idea being that there are two tests on this. One is called an extrinsic or objective test. The other is an intrinsic or subjective test. An extrinsic test is objective, and it's met as long as the plaintiff or the person bringing the suit can demonstrate through expert testimony, usually they call in musicologists, professors of music theory, to say that the similarity in the composition, in the notation, the melody, the beat, was substantial to protected elements under the copyrighted work. That second element I talked about, which is the intrinsic test, is subjective. That reflects a jury's determination of the similarity of the total concept and feel of a song. So those are the two primary things that the court looks at.
Chris, so is it necessary to show that a defendant intended to copy from a work, or just that they had access to the work and the work that they produced is very similar?
It's a really great question, and continues to open a whole can of worms for artists, unfortunately. Under copyright law, it's actually not necessary to show that the defendant intended to copy from a plaintiff's work, or that the defendant had a specific state of mind when they were copying. There's a early case of this that's a good example, Fred Fisher Incorporated versus Dillingham in 1924, which is known as the subconscious copying case. Basically, Fred Fisher Incorporated owned the composition rights for Dardanella, and then a famous musical theater composer named Jerome Kern wrote a song called Kahlua for an opera. And both songs use the same ostinato, which many musicians in our audience will know, but for those who don't know, means it's a recurring musical phrase. And the court had used, again, those two factors that we looked at. The first one being access, and the court said, yes, there was access. Dardanella was a very popular song, and the defendant, as a professional musician, should definitely know it. And the second was substantial similarity, and the court found that the ostinatos that were used in both songs were, quote, exactly alike. And what's important in that decision is the fact that the court acknowledged that Kern, the defendant, did not intentionally copy it, but in fact, probably just had it in the back of his mind after listening to Dardanella all the time. But they said that it had no bearing on the case. This was still a case of copyright infringement. So I think those conclusions and the conversation that we've been having on copyright infringement leaves us with two lingering questions for artists, for lawyers as we move forward in this world. The first one being, currently in the age of Spotify and Bandcamp and music on demand, tech has made it so it's reasonable to access anything. Music is more accessible than ever. So that means that the first prong that the courts look at in access seems to be kind of a given. And as a result, it means that substantial similarity is now weighted much more heavily inside of these cases, which importantly goes to the second point, which is, as many of the musicians in our audience know, most pop music relies on the 12-note Western scale, which in order to be aesthetically pleasing is kind of restricted to not that many variations, which means that if substantial similarity is what matters the most, then how can the law meaningfully draw a distinction between something that is a coincidence and something that is infringement? These are questions that the law needs to continue to catch up on. And it's what we're going to talk about in terms of our conversation on fair use. And later on also when I talk about things like de minimis infringement.
And these are fascinating questions, Chris. Thank you so much for that section. I do want to interpolate one question from the audience, if possible. Michelle Shocks was asking why discussions with those who devalue copyright usually begin with a definition of copyright as to promote the progress of science and the useful arts, and leave out the important part of the promotion by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And I think that this, Will have some interesting things to say on this in his section on fair use now, in terms of the idea that focusing on this purpose of the copyright regime might devalue the monopolistic protection that is offered to creative output of individuals. So I might begin with a question for Will. If I, as an individual, am accused of infringing, when do I have a fair use defense?
Yeah, so thanks, Anil. I'll also say, just to introduce myself, it's really great to be here. I love talking about this stuff. And I want to echo something that Chris said, which is if you guys have questions about anything that we're saying, definitely throw it into the chat. We're hoping to have time for a Q&A at the end. And the more stuff you give us, the better advice or feedback we can give you guys. So Anil brings up a good question based off of what Chris is saying, which is there's a whole infringement regime and there's legal risk associated with taking a sample or interpolating another composition into your music without paying for a license. Now, a lot of people circulate these kinds of myths about fair use, quote unquote, and when doing this is okay. And here are some big ones, right? One is I'm only using 15 seconds, or I'm only using 30 seconds, or I'm only using 5 seconds. Therefore, de facto, I'm not infringing, I'm totally in the clear. Another one would be, well, my music doesn't really make money right now, or my podcast is supposed to be not for profit, or it's supposed to be educational. So that means in every instance, I am going to be subject to fair use. In other words, I'm not going to be infringing under the Copyright Act. Or another one would be that I've manipulated my music in such a way that I don't get takedown notices. It doesn't come through the content ID on SoundCloud or on YouTube. And that means de facto, I'm subject to fair use and I'm not infringing. As it turns out, the actual system is quite a bit more complicated than this. and it requires us to think about things slightly differently. So if we could move to the next slide. I want to clarify two things about fair use. The first thing is that fair use is defensive. It's a defense against an allegation that you've infringed somebody's copyright. So it's not like a positive right that you have in the way that maybe you would say that you have a right to free speech or something like that. When you're invoking fair use is you've been served with a cease and desist notice, or somebody accuses you of infringing, and you say, no, 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 my use is actually fair, but it's already potentially an adversarial situation. So fair use is generally defensive. The second thing that I think is really important is that fair use isn't a rules-based system, or at least not necessarily. It's not like there's specific uses that are always going to be in the clear, and there's specific uses that are always going to be infringing. There's a lot more of gray area, as we've kind of illustrated on the slides with this fair use continuum. And so instead of thinking about it categorically, what you want to do is think about what is going to increase or decrease the level of legal risk that I'm putting myself at. Some practices are going to be less legally risky, and some practices are going to be a lot more legally risky. And we want all of you to shift your practices over to the less legally risky side. I'll also say one more thing, which is something that Chris already kind of mentioned, but is so important. The easiest way to protect yourself legally is just to make sure that you have licenses for any compositions that you're interpolating or sound recordings that you're sampling in your music or your podcast or whatever. Fair use can be effective, but the most effective thing, the way to seal the deal, is to acquire a license. And that's something that Chris is going to be talking about in a lot more detail as we get later into the presentation.
Yeah, Will, fair use has 4 distinct factors. How do they come into play?
Absolutely. So we'll go to the next slide. You already talked about this a little bit, Anil, right? The 4 factors of fair use are complicated, like the whole fair use doctrine. Part of the reason they're complicated is because they're not really weighted equally in practice. Most people would tell you that the most important factor of fair use is what we've listed as number 1 here, the purpose and character of your use. And often this is kind of conflated with the idea of transformative work. So the idea is the more you're transforming the original work and kind of creating something new out of it, the more likely your activity is going to be covered in fair use. Marco Castro talked about Weird Al a little bit earlier in the chat, and I love any opportunity to talk about Weird Al. I actually think that his work kind of illustrates what's going on with factor 1 of fair use. And I'll also say that there's a lot of different axes in which this is going to play out. So I'm just going to give you a little snapshot of one way that the legal landscape may work on factor 1 of fair use. So the distinction that I'm going to talk about is between parody and satire. These sound like synonymous words when we use them in everyday language. Turns out they're not legally, like a lot of things legally are not. A parody is something that's usually protected by fair use. This is going to be something that's making fun of an original song, or it's making fun of an artist. You're sampling something, or you're interpolating a composition, or you're just using the melody of something and changing the words because you want to poke fun at the artist. If we want to use the Weird Al example, this is something like maybe Amish Paradise, right? He's making fun of Coolio with that song. He's kind of deflating Coolio. That's a pretty classic example of parody, and that would probably be lower risk on the risk scale that we talked about earlier. Satire means I'm taking somebody else's song and I'm using it to make fun of some third party. So we're going to talk about a case in a minute where they take a song and use it to make fun of the President of the United States, Barack Obama, but the song doesn't really have anything to do with Obama, and that's going to be less protected. It's going to be higher legal risk under the fair use framework. So I want to run you guys through a couple of cases just to kind of illustrate this. The first one that we're going to talk about is Estate of Smith versus Cash Money Records. It was just appealed in the Second Circuit and decided earlier this year in 2020. It's really cool. It's about a Drake song called Pound Cake, which starts with about 35 seconds of a sound recording of a jazz guitarist named Jimmy Smith, who's talking about the jazz greats and how new music doesn't really compare. I think we have a clip of that to play.
Good God Almighty, like back in the old days. You know, years ago, they had the A&R men to tell you what to play, how to play it, you know, whether it's disco or rock. But we just went in the studio and we did it. We had champagne in the studio, of course, you know, compliments of the company, and we just laid back and did it. So we hope you enjoy listening to this album half as much as we enjoy playing it for you, because we had a ball. Only real music's gonna last. All that other bullshit is here today and gone tomorrow.
So cool song. Turns out that this is something the court says would be protected by fair use. Why? Because Drake is using the Jimmy Smith jazz organist sample to make a commentary on what Jimmy Smith is saying. Jimmy Smith is saying all this new music, it's not really good. You need to go back to the old stuff. And Drake with Jay-Z are saying, no, we don't think that that's right. You see the commentary or kind of statement aspect of that means that it's more likely to be protected by fair use. Other examples show the opposite. So there's another case called Henley versus DeVore, where Charles DeVore, who's a politician, takes Don Henley's song Boys of Summer, which he wrote in the 80s right after he left the Eagles, and he changes the words to make it about Obama. He calls it The Hope of November. So it's the same tune, and it's all the same. All the words have been changed to be about the Obama administration and how terrible Obama is, etc. This is an example of something that the courts say is not covered in fair use, because Charles DeVore is not really making a statement about Don Henley's original work, right? Drake is maybe trying to say something about Jimmy Smith. Charles DeVore is just using Don Henley's melody to make his own independent point. And the Copyright Office says this isn't something that we want to protect, or this isn't something that we're as worried about. So this kind of shows you how factor one is going to shake out. As I say, it's a lot more complicated than this. In general, things that have educational uses are more likely to be found acceptable under factor one fair use. In general, things that are making some sort of commentary are likely to be found on factor one fair use. Neil, can you think of any other kind of big cases or issues that most courts would say is acceptable under factor one?
Yeah, so there's another really interesting case, Abilene Music v. Sony Music Entertainment in the Southern District of New York. Ghostface Killah quoted a part of very recognizable lyrics, the chorus to "What a Wonderful World." Actually, I believe the introduction, the first few lines of Louis Armstrong's "What a Wonderful World," interpolating the melody as well without an attribution or seeking permission. And the court determined that that was a transformative parody because the target of the criticism offered in the quote and the substance of the song was the original song and the worldview that it represented, this kind of naive, rosy-eyed kind of perspective on life, as opposed to the kind of realistic, hard-bitten inner city experiences of crime, incarceration, and drug abuse that were the subject matter of the Ghostface Killah song. So yeah, that's just a good illustration of when an interpolation, a use of some copyrighted material is transformative under factor one of the fair use statute.
Exactly. So just in kind of summation, and this speaks a little bit to what you were saying, Michelle, in the chat, if something is engaging in a substantive way with the original composition, the way that Drake is engaging with the jazz organist, then that's something that's likely to be covered under fair use. If you're just using someone else's song to kind of promote your own art or your own material, it's less likely to be protected. And that tends to be the important factor. The other factors are also worth talking about, and Chris is going to talk about some in detail. So factor two is the nature of the copyrighted work. You guys are all musicians or interested in music, so we're going to be on the same page there. Music is going to be subject to slightly higher scrutiny than something like journalism or fact-based information. So In general, music isn't protected as closely as some other kinds of copyrighted products, but that's okay. We'll go to the next slide now. The third factor Chris is going to talk to you about a lot, so I don't want to step on it. This is the amount and substantiality of the portion taken. This is where we get that mythical 30-second rule. In general, it is true that if I'm only using 5 or 10 seconds of a song, that's going to fare better in a fair use analysis than if I'm using the whole song, or if I'm using half of it, or if I'm using 2/3 of it. But as I say, this is complicated in different jurisdictions, and Chris is going to talk to you guys about that. And then also, factor 4 is the effect of the use upon the potential market. So the idea here is that if I sample a song and it decreases the market for that original song, it could potentially depress the sales of the original songwriter or composer or studio that released the song, then that's going to make it less likely that I can mount a successful fair use defense. But in general, conventional wisdom says that factors 1 and 3 are the ones that you need to do your own kind of makeshift fair use analysis. That is, looking at the nature and purpose of the work, and also looking at the amount and substantiality of the work that was taken. So we'll go to the next slide, if that's okay. And if you look at this, you can kind of see how the fair use analysis could shake out in a number of different cases. For example, if I have a podcast, it's a music criticism show, and I want to use 5 seconds of Jimmy Smith, right? A jazz organ track by Jimmy Smith, and I want to highlight some aspect of his musicality. That's more likely to be safe under fair use, although nothing is sure. If I want to do a full-length parody of some song, and I have an argument that it's connected to a criticism of the original songwriter or composer, that could be covered under fair use, but it's more likely that it's going to create litigation, or that the defense isn't going to be as successful. In other words, it's legally higher risk. Of course, the most high risk is I'm just taking somebody's unedited sample, 45 seconds or 50-second hook, and putting it into my song. In that case, the likelihood of litigation goes up by quite a bit. But as we're going to say again and again and again, the one thing that you can do to make sure that you're kind of legally safe is licensing. So if you pay for the license, then you don't even have to get into this kind of complicated fair use realm. And I think we would say that the best practice is almost always just going to be to make the purchase.
Thank you so much, Will. So we will turn back to Chris now. And as we've learned, fair use is a defense to copyright infringement. But do you always need to invoke that defense under similar circumstances? What if you didn't take much of the underlying song or work? Is that a defense, legally speaking?
Right, so it's a great point, and thank you, Will, for teeing it all off. A lot of the time, what this defense is called when you hear somebody say, I only used a few seconds of it, so it's probably fine, which again is a myth that we're trying to help dispel to protect you as artists. But that comes from something called the de minimis defense, which is Latin for about minimal things. Basically, in copyright law, this means that the court will not find infringement if it can be determined that the average viewer or listener cannot recognize the appropriation. Now, there is a specific test about this that depends on how integral or how important that part of the song is to the original work. So for instance, if you're going to be taking a really iconic guitar riff from a song, you're going to be running a higher risk of not qualifying for a de minimis defense than if you took maybe something more obscure. But it's important to note that even a small amount of use can require permission and appropriate licensing. There have been cases where courts have found that even samples that are only 2 seconds long constituted infringement. So it's always better to err on the side of caution. The interesting thing about the way that courts have treated the de minimis defense as it pertains to sampling is that it's a little bit complicated because of something called a circuit split. So without getting too far into the weeds, just to explain what is a circuit. The United States federal appellate court system is split into 13 circuits across the United States. And these are the courts that sit right below the Supreme Court of the United States, the supreme law of the land, governing the supreme law of the land. But as a result, these appellate courts have a substantial say in determining what the law is in their regions of the United States. So on the issues of de minimis exceptions and sampling, the circuits don't all agree. That's why we call it a split. And it means that how the court favors samplers largely depends on where you are located and what circuit you're located in at this moment. So again, without getting too deep into the specific litigation that occurred, the main split can be found between the Sixth Circuit and the Ninth Circuit. The Sixth Circuit occurs in Tennessee, Kentucky, Ohio, and Michigan. And this is a region where the court has refused to recognize any unauthorized sampling or de minimis defense, regardless of size, basically saying, if you don't have a license, don't sample. It's possible that the reason why the court is so strict on this is because of community influence on judges from the area that they govern over, which is primarily, as you can tell from the states, a really big country music hotspot. As a result, they may be less open to sampling and maybe more protective of copyright holders. On the other hand, in the Ninth Circuit, which is massive and covers Arizona, Nevada, in Idaho, Oregon, Montana, and Washington, and most importantly, California, they have had cases where they've applied the de minimis exception to sampling, where an average audience would not recognize the appropriation. But again, that doesn't mean you have free license to sample whatever you want without authorization in the Ninth Circuit. It just means that there is a higher possibility than if you were in the Sixth Circuit. So what does all of this mean? It means the court currently does not, and probably will not for a while, have a definitive ruling on de minimis use and sampling. So to avoid those issues, it's always advisable that a producer, musician obtains a license, gets permission from the owner of the sound recording before you sample.
That makes a lot of sense, Chris. So it's always advisable that a musician or a producer gets a license. But how does an artist go ahead and get that license?
It's a great question. So for a sample, you're going to need 2 licenses. Remember how at the beginning with copyright discussed that there are 2 different copyrights that exist in a work of music. So what you're going to need first is a mechanical license. This is a license that's given for the composition, the notes, and the lyrics of a song. You may be familiar with mechanical licenses because you need one anytime you create a cover. It is an obligatory license, which means that you can't be denied the license, and the rights holders have to give it to you for a rate, which is statutorily set at 9.1 cents per song for songs that are under 5 minutes long. And I did get some questions earlier in the chat and before the panel about what happens if you're creating a cover on YouTube or if you're translating a song. Well, if you're translating or creating a cover, you're creating a derivative work from it, you're going to need the mechanical license. And then as it pertains to sampling, again, you also need a license to use the sound recording because you're using a specific fixed recording or track inside of your song. And usually this license will come from the record company or other sound recording owners. I think this would be a great time to just interject with a great question that I got earlier about using sampling and street sounds. Something like the wait noise from a traffic light or the ambient noise from a cafe. It's a really great question. So in order for something to infringe on copyright, the work that you are creating or using has to be protectable. It has to be original. And it is highly unlikely that the court would find that the noises from a street cafe or the wait symbol are protectable under copyright law. To get more details on that, you can look into the US Copyright Compendium, specifically Chapter 900. I'm going to drop the link right here in the chat for you to look at, because that's going to have just a lot of detail on what constitutes originality. But basically, if you're doing something that is really generic, like the noise from a cafe, you should be set, unless you are using somebody else's specific copyrighted recording of a cafe. But without getting too far into those weeds, how do you get that license? So first, you're going to need to find out who the rights holders of that song are. One of the ways, not the only way, but one of the ways you could do this is go to a PRO or performing rights organization website, groups like ASCAP or BMI, and you can search the title of the track if it's registered in their database to find information on who is the publisher, who's the record company of this track. Again, it's not the only way to find it, but it's a really good way. To maximize your success in doing this, be ready to offer as much information about the song, the publisher, what you're going to use, how you're going to use it, how many units of your song are you going to distribute, what kind of media are you going to use. This is all really important to give to the publisher or administrator, so that way they can understand how you're going to use it and then eventually get into negotiating costs. When it comes to costs, remember that a publisher and a record company can always say no. They don't have a law-imposed obligation to give you a license to sample. And while there is a statutory fee for mechanical licenses, again, that was that 9.1 cents, there is no law set fee for sampling costs. So those are negotiated directly with the rights holder. And it depends a lot. The cost can range because of the popularity of your song, the projected popularity, maybe how you're going to create that licensing agreement. Sometimes it's flat fees, sometimes it's royalties, sometimes it's co-ownership, or even turning over all of your ownership to the original rights holder of what you want to sample. So it varies a lot, but one thing to also note, a lot of artists and labels sometimes don't like authorizing samples because they're afraid that the new song is going to diminish the value of the old one, or more frankly, they're afraid that your new song is going to suck and they don't want their sample inside of your work. One of the good ways to try to get around this, especially if you're an independent or unsigned artist and you keep hitting this wall of, I've never heard of you, so I'm not going to respond to your inquiries, is to try to show these rights holders that you're willing to write a check in advance, that you are ready to pay, and that they're going to be more inclined to give you clearance on that.
So Chris, what if you can't get a license, or if the process is just too cumbersome? What are other legal options for you as a creator?
It's a great question. So the good news is this process, there seems to be a lot of roadblocks. I'd say definitely try. And then if you hit too many roadblocks, you do have some other options. The first one is you can always try contacting the artist or the songwriter or maybe the representative directly. Again, the final decision is made by whoever owns the song or the sound recording. All an artist can do if they don't own it is advocate for you, but sometimes that can be effective. This isn't an example of sampling, but when Greta Gerwig did her movie Lady Bird, she actually wrote direct letters to Justin Timberlake, Alanis Morissette, Dave Matthews in order to ask them, hey, can I please put your song into my movie? So sometimes reaching out to them with an impassioned ask is enough. So shoot your shot. And then the other things you can do is search Creative Commons. That's the licensing organization that compiles media for free use, including images, music, etc. See if you can find a sound from the public domain. You can find these in several different ways. Like YouTube has a digital library of sounds called the YouTube Audio Library. It has royalty-free production music and a lot of clips from the public domain that is good to use. The important thing with that is always search up individually if a song is in the public domain. Don't just assume, oh, I think this is old enough, or I don't think they have a copyright on this. Make sure it's clear before you use it. Another two options you can do. One, find reputable sample packs or sample clearinghouses like TrackLib. There's a lot of them out there that come with sets of royalty-free legal tracks for you to use. But one caveat again, every digital track library comes with its own set of terms and conditions regarding commercial use, licensing. So make sure that if you're going to be using this music, especially commercially, read over those terms. Don't ever assume anything. And finally, if you only get permission to use part of the composition through a mechanical license, again, that's the license that deals with the musical notes, the lyrics, the composition of a work, but you don't get a license for the original sound recording, then you are legally permitted to create your own sound-alike recording and use that sample. This is a process called interpolation. We actually saw an example earlier with what Anil played, where you basically make something that sounds alike. You use your own instruments, you have somebody else sing it, you record it. It sounds really similar, people might recognize it, but as long as you have the mechanical license for that, you're fine to do that practice.
Thanks so much, Chris. So Will, you were speaking earlier about fair use in general, and just with a view to tying the two defenses together conceptually, are fair use and de minimis really robust options for defendants? Can people rely on them typically, or is it usually just better to revert to getting a license?
So I'm going to repeat what Chris said and what I said earlier, because I think it's really important. In general, it's much safer and less legally risky to get a license. So in some cases, fair use and to potentially a lesser extent, de minimis are going to work. As I said before, if you're trying to comment directly on an original work and you're only using a small sliver, 5 or 10 seconds of a song that you're trying to sample, then maybe you have a good fair use case. But in general, the thing about fair use is that it's largely defensive, which means, and people were pointing this out in the chat, it's definitely true, well-resourced artists with expensive lawyers are going to be much scarier and much more difficult to wrestle with than kind of thinly resourced artists who are maybe more up and coming and are trying to get access to music for samples or whatever. Because of that, in general, it's much more kind of legally prudent just to make sure that you secure the rights with a license. Otherwise, you're kind of in this last resort domain where it could go your way if you have a really good case, but if the opposing counsel is really well resourced, or if they have arguments that you didn't think of, you can end up in a lot of trouble. I would also add that this is true kind of regardless of how much money you're making off of your music at this point, how successful you are as an artist right now. There's a million kind of horror stories of people saying, nobody's listening to my music, so I'm going to sample and infringe, and it's not going to be a big deal. And then finally, when they get the success that they've been looking for, all of a sudden they're in a bunch of legal hot water because they didn't take care of the rights early when they potentially should have. So if you have the ability and the resources, we strongly recommend just making sure that you get those licenses locked down.
Thank you very much, Will. I think that's a really important point to stress. I think that concludes the substantive portion of our discussion. And if there's time, we were hoping to address some of the questions that you all asked in the chat. And without further ado, I think I would turn to Will for that.
Yeah, so one thing that somebody asked earlier is how all of this applies to YouTube and online. How is a commercial recording different from posting something on YouTube? Are there additional rights that need to be considered? Brian, I was wondering if you had any thoughts on that might be helpful.
Well, YouTube has its own special terms of use, and like any format, you can always be subject to takedown if you upload any unauthorized content, and that would be along the lines of what's been discussed today. So the same rules apply there as any other platform in terms of using unauthorized content. Typically, you might see people doing lots of cover songs, and those generally are okay for the most part if the cover is of a song that has been licensed via the PROs or via the publishing companies to YouTube. Typically, just uploading somebody's existing record from a record company, that could be subject to a takedown notice. So same rules apply there as anywhere else.
Perfect, thank you so much. So another question, I'll just throw this out to whoever wants to take it. Olivia asked in the chat, can you get a license retroactively and still be okay? So if somebody sends me a cease and desist letter and says, I think you're infringing, can I just get a license after that point, or am I already in trouble?
I can briefly touch on this, but obviously I'll defer to Brian's expertise. Seeking licenses after the fact retroactive licenses are often disfavored because they don't support the policy priority of protecting creative expression beforehand. They encourage kind of infringement and then asking permission after the fact. An alternative arrangement to retroactive licenses can be the covenants not to sue for copyright infringement, which you again would have to negotiate directly with the rights holder, the person whose composition copyright or sound recording copyright, or both, as the case may be, you've infringed. But I'm sure Brian would have a good perspective on this.
Yeah, retroactively is what you sometimes find happens when a song has been remarkably successful and the copyright owner or owners don't want to disrupt the gravy train. So they'll negotiate a settlement and get a share of the song ownership, the new song, and also get a share of the income from the sound recording, if that was part of the sample too. So, you know, on a smaller scale, maybe you request a license after you've committed the infringement and you get denied, and then your song gets subject to takedown. So, you know, taking the stance of it's better to ask forgiveness than permission isn't always a great approach, unless you have the money to pay for potential consequences, which could be needing to hire a lawyer if you really want to keep your song up there, and or risking that your song gets taken down. So, you know, money kind of rules at the end of the day. Lots of times it creates incentives for negotiation or creates disincentives where you may not have a lot of leverage to work with.
Thanks for that, Brian. Just to retouch also on another question that I got about interpolation, just for extra clarification. So when you're doing interpolation, you are basically creating a sound-alike sample where you are re-recording something with your own instrumentals, your own voice, or the voice of a musician you've hired. What that means is you don't need to get a license for the sound recording because you're creating your own sound recording, but you do have to get a mechanical license for the part of the song that you are using. And the mechanical license is a compulsory license. That's what we discussed earlier with the statutory fee for the 9.1 cents. But so it's relatively easy in that case to create your own sound recording and then use that as your sample. So hopefully that.
Yeah, I just want to elaborate on one thing that Chris had mentioned in terms of the mechanical and the compulsory. That only applies if you're not changing the fundamental character of the song. If you're going to interpolate a portion of a song, really that's creating a derivative of the original song, and you would need specific permission from the song owner, the copyright owner, in order to do that.
Just to add, I think it's whenever one alters the basic melody or fundamental character, which seems again like a very broad range of circumstances in which it would be better off to do what Brian's saying. Sorry, Will.
Yeah, I was just going to say, I think we have time for maybe 2 or 3 more. We'll see how quickly we can get through them. Melissa had kind of a follow-on to what you were saying, Chris, and you were saying, Brian. So let's say that we or she wants to use sounds for a movie project and wants to credit the source. Is there legal risk involved in that if there's accreditation? Are there different sorts of documents that need to be drafted? What do you guys think?
Accreditation is a kind act, but it's not an act that's going to take away your obligation to get permission if you want to use that work, legally speaking. So, you know, that's also one of those myths about what fair use is. If you give credit to the owner, then it's a pass, but the law doesn't recognize that. It's a kind act for sure, but doesn't give you any extra protection.
And then one more follow-up from Olivia. So if I'm an artist and I want to release a cover of a song, then Chris, I'm definitely going to have to get that compulsory license that you talked about.
Yeah, so again, and then back with what Brian's clarification was earlier, if you're not changing the underlying structure of the song and then you're using a cover of it, then you're going to get that mechanical license, and mechanical licenses for covers are compulsory.
And then maybe one more. So Bianca a little bit earlier was talking about different genres. Do you guys have any sense of whether certain genres where sampling or quotation is kind of part of the musical fabric, and I'm thinking here of hip hop or rap or jazz, are treated differently by the courts than something like pop music? And to be even more specific, if I'm trying to figure out to sample something, is that something that I should be considering? Am I safer if I'm doing hip hop or rap music?
Well, in the early days of rap, it was a common practice to sample artists like James Brown or Parliament Funkadelic, and they wound up getting paid because there was their song rights that were being used. So you know, genre culture doesn't sway the courts any. it may sway what happens outside the courts, whether somebody wants to take action against another artist for sampling their work. You know, in some genres, it might be perceived as, you know, not being cool to sue somebody for using their songs, you know, their song, because it's what we do. We use each other's song. But that doesn't take away the right. And so if somebody wants to sue somebody for using their song, they certainly can.
I think the main difference is just that, you know, hip hop has, though it has become less sample heavy over time, in part due to concerns about infringement and artists, albums, you know, losing them money, or you know, effectively being enjoined from releasing the albums due to an inability to pay out. Genres like pop and other genres just in fact are less sample heavy. But again, I think I would restate Chris's advice and Brian's advice that if you are using sample libraries for your drum kit, your bass patch, whatever it might be, to read the terms of service for those, because again, you could be infringing just by using those. So
yeah, those license agreements, they're very specific in what they're licensing you to do. And also some, if you read them carefully, they're not waiving income for certain uses. So it's wise to read those license agreements when you're using product from sample packs.
Will, does that conclude the questions that we gathered?
Well, I think we are running out of time. I'll put in one more plug for the RAP project, which is just, I think that the email should be on the screen. We are always looking for new business. And if you have an issue, a legal issue that you think we could help you with, it's no guarantee that we'll be able to work with you in the fall, but we'll definitely send you a follow-up email and let you know if it seems like the kind of project we could help you with. So hlsrap@gmail.com. The big benefit here is that this legal advice is going to be totally free. So financially, it may be a good move, and we'll do our best to try and help you guys out.
All right. Well, thank you, Will, and thank you to all of the panelists, and to Brian, as well as to Mondo for this panel. We've really been appreciating the relationship that we've had, and we're just hoping that we're giving helpful advice to all of you through these sessions. So, yeah, thank you so much, and I will pass this on to Joanne to wrap up.
Thank you so much, Neil. Thanks to all of our wonderful panelists, and a special thanks to Brian Price, Clinical Professor of Law at Harvard Law School and Faculty Advisor and Supervising Attorney at RAP. And thank you all for joining us today. We'll see you all very soon at our next Zoom session, and of course at Mondo NYC, featuring our CLE and Pro Bono series, October 13th through the 16th. Stay safe, stay well, and have a great rest of the weekend. Bye-bye.
Bye-bye, everyone. Thank you, Joanne.
Thank you.
Bye.